from the courts. It's here to tell us all about it. But did you also know that the chairman of the ad hoc committee, which has been investigating the leak tape, purportedly plotting to remove IGP Dr. George Akufu Dampari, the chairman of the committee, Samuel Atachia, he's been criticizing the committee's report. In fact, he's saying that the committee's report is anemic and it lacks substance that is needed for parliamentary action. You know that Parliament has already looked at the report, they've debated the report, and the Speaker of Parliament has instructed that the report be sent to the President for the President to act on it because Parliament has actually adopted the report. Everybody on the committee signed that report except of the chairman of the committee. And the chairman of the committee, Samuel Atachia, says that that particular report that was prepared by the committee is anemic. And he's stating that the report concluded that 3 senior police officers, COP George Alex Mensah, Superintendent George Asari, and Superintendent Emmanuel Eric Jebi, had misconducted themselves, which is a major offense under police regulations and all that. But he also believes, and this is something that he said on the floor of Parliament, he's urging his colleagues to reject the committee's findings due to its lack of logical foundation. And he made this argument on the floor, even though at the end of the day, the report was adopted and it was forwarded to the president. But if you are quoting Samuel Atachia, let me just quote what he said. This is the quote. You don't just listen to people who will come before a committee and that will bring you to a conclusion of a matter. You delve into matters. A committee of parliament is not a conveyor belt. They are supposed to delve into this matter. It lacks substance for a plenary to find, with the greatest of respect, any decision on it and to uphold this report. And I urge this House to reject this report because there is no foundation of evidence for this report. And we shouldn't make a resolution based on such an anemic report. This is according to Samuel Atachia. And this is the quote that he put out on the floor of Parliament. But of course, there are those who opposed, like James Agalga, who is also the vice chairman of the committee. He countered Mr. Atachia's comments, saying that, look, a proper work was done. A number of issues were looked at, and they believe that the committee's work is a good one. But eventually, like I said, the committee's report was adopted by the plenary. The Speaker of Parliament has instructed that the committee's report be sent to the President for him to take some action on it, because the President is the chairman of the Police Council, and so if there is misconduct of this sort within the Ghana Police Service, he thinks it's appropriate for the President to take some action on it. Much later on, we're going to stay on this particular subject matter. And as we're staying on this subject matter, we'll be speaking to a security analyst, to find out what his thoughts are on this. Of course, considering that this borders on security, because the IGP is in charge of our security, is he not? And if there was a plot to remove him and there was a plot to sort of get a favorable person who is sympathetic to the plight of the MPP in there so that the elections can be won, so to speak, or there can be some machinations to let the security agencies be in favor of a particular political party, which is the MPP, in the upcoming elections. I mean, that tells you that this is a serious security concern. And we'll be speaking to a security analyst, like I said, on this particular issue. Whether or not he agrees with the chairman of the committee, Mr. Samuel Atachia, the Honorable Samuel Atachia, that the report is anemic and there were certain key details that were supposed to be in there that are not in there. And it looks like it's becoming a conveyor belt. We'll talk about that. But Mutala Inusa is here in the studio this morning. Mutala.
Malanta.
What's been happening in court?
Yes,
Mutala?
yesterday.
What's been happening in court?
Yesterday was a very, very busy, very, very interesting court day. Interesting because the cases that came up yesterday, of course, everybody is itching. Everybody wants to know what is happening and all that. The first that I want to talk to you about in relation to the men's gold case.
Mm-hmm.
Yes, Nana Pia Mensah. aka
Nam1,
and then 2 of his companies, Men's Good Ghana Limited and then Brew Marketing Consult. They are facing trial. So somebody will be asking, well, how come a company is an accused person? Yes. So if a company is facing charges, it is the head of the company that is, in fact, who is doing everything. So Nana Pia Mensah is representing both companies as accused persons and all that. So you notice that prosecution called 11 witnesses out of the, in fact, 9 witnesses out of the 11 that they indicated that they were initially going to call. So after calling the 9, they closed their case. Then lawyers of Nana Apia Mensah, number 1, led by Kwame Boafo Kufo, indicated that they are filing a submission of no case. A submission of no case is that you are telling the court that based on the testimonies of all the witnesses, there's no case for Namwan to be called upon to answer. So he should be freed at that particular point. The court should not ask him to, the court should not even allow him to talk, because for them, they were of the considered view that the testimony, there's nothing that shows that Namwan has done anything wrong based on the charges that have been pressed against him and all that. So even if the lawyer did not file, the court will still have to make a determination of same. So then the court asked them to file their written submission, both the defense and then the prosecution, which was done. The court gave them the opportunity to come highlight on the key things that they want the court to note and why they are saying that lawyers of Nana Apia Mensah are saying that, look, Namwan should be made to go home, and prosecution will also have to highlight on why they are saying that, no, he has a case to answer and so he should be compelled to answer. They did that, and yesterday Justice Ernest Owusu-Dappah delivered his ruling, in fact 110 pages, so you can understand, well over 3 hours between from. So the case was called at 11:22 according to my watch, and we concluded the case at 2:36. So when you do the calculation, you know that very, very well over 3 hours this case was before your friend Justice Ernest Owusu-Dappah. And Lantam, the judge gave a background to the case. They recounted the counts and then the charges. The count formed the charges. So we have 39 counts. It doesn't mean the charges are 39. So for instance, if you take the counts, the defrauding by false pretenses, which is a charge, there are 22 of them, which are involved in the 39. So when you take the count of defrauding by false pretenses, it was counted because the individuals who were defrauded,
22 of them. So 22 counts.
Only one count
of that
only
charge.
One charge.
Yes.
The one charge.
So he defrauded
22
by false pretense
allegedly
22 times.
Absolutely.
So that's the count.
So that is the count.
Yes.
So if you put the charges together, Namwan is facing 7 charges.
7 charges.
7 charges. But those 7 charges spread into these counts that we are talking about. So the court picked them one after the other. The first count was in relation to selling gold without license. And the court said clearly, Namwan and Brew Marketing Consort sold gold. And so the court want to understand from them whether indeed they have license to do that. So the court said there is a prima facie evidence there. Then the second count, which has to do with operating deposit-taking business without license, the court said that it appears that the Bank of Ghana that is supposed to endorse that particular transaction, authorization for that transaction business to go on, seem not to have endorsed that. So therefore, Namwan will have to mount the witness box and offer explanation to that. Then went to count 3, which is the third charge, inducement to invest. And that is one quite very interesting charge there. And you know, one of the things that the court said, the reason they preferred that charge was to the effect that they made the case, the prosecution made the case that Namwan used prominent people, celebrities, to influence the public to invest in men's gold when they did not have license to do so. And some names came up. Joycelyn Dumas was mentioned, Becca was mentioned, Jackie Appiah was mentioned, Stoneboy was mentioned, among others. So the court was of the view that yes, these beautiful celebrities that you used, in fact, we have a gentleman in there, so he cannot describe a man as beautiful. But of course,
some people describe men as beautiful.
Okay, so then let's just take it. So the court is saying that if you look at the artwork, it was so beautiful of these celebrities, and nobody can say that they did not influence whoever is making the choice. Because when you see Jackie Appiah, say, oh, you've been seeing Jackie Appiah, you know that Jackie Appiah is a very noble person. Stoneboy is a very noble person, and so once they are endorsing such a business, it is easy for you to think that it is a legitimate business. So the court said that you want to hear from Namwan's opinion on that. Then come to the 22 counts of defrauding by false pretenses. Now, prosecution abandoned 3 of them along the line because the victims in there were unavailable. So it reduces that count to 19. So Naman was acquitted on those 3 counts, that defrauding by false pretense, that prosecution witnesses or those victims did not avail themselves. So the remaining 19, Justice Ernest Owusu-Dapai saying that the court want to hear from Naman. Then fraudulent breach of trust, 7 counts. The court said there are issues that the court want explanation to that, and so Naman is called upon and his businesses are called upon to answer. Then the last counts, or the remaining 7 counts, all put together, money laundering. The court say, look, if you look at the other legs of the counts or the charges that the court has already ordered him to open his defense, it will not be fair if you say Naman should be acquitted on the charge of money laundering. So 7 counts of money laundering, the court is saying that Naman should open his defense. So in effect, Naman has been called upon to respond to the remaining 36 counts, which cumulated into the 7 charges that I have mentioned, for the court to make a determination. It doesn't mean that once the court has found that there's a prima facie evidence, Naman is guilty. No. What it is now is that the court now wants to hear his side of the story. Then the court can now make a fair assessment or a thorough examination of what prosecution witnesses have said, juxtapose that with what he as his defense will be, and now the court have a balanced idea of what determination to make based on what the law says and all that. So that is how come, or that is where yesterday Justice Ernest Owusu-Dapai's ruling on the submission of no case ended. But Lantam, for the first time in court, we've been speaking to the man himself, Nana Appiah Mensah, aka Naman, what his opinion is now that the court has ordered him to open his defense. He said he disagrees with the decision of the court, and he will consult his lawyers to see if they will seek a redress. And he's also been making the point that this very trial is truncating the whole process. Let's hear from Naman.
A chunk of it has been dismissed, which is fine. We disagree. We very much disagree. But it is worthy of note that the disagreement does not in any way erode our confidence in the judiciary and in the courts. Yeah, so I would speak with the defense legal team, and then we would consider and then explore all necessary rights to redress, under the parameters of rule of law. So, it's a win for Ghana. It's a win for rule of law. We have always maintained that we are not guilty, and we still stand by that. And listening to the lengthy ruling, certain keywords were very, essential. And they were like consistent. So, for example, there were words like presumption, we presume, it appears, it looks like, it seems. What that tells me is that it's just like, viewing it from on the face value, right? And not necessarily going into the fact of the matter. So I wouldn't also want to go into the merit or the demerit of the matter, because this is just the prima facie, which is like looking at it on the face value. So, well, it could be a mirage, and this is just one, person sitting down looking at it. So, yeah, once we disagree, the law permits that we can always take it to, an appellate court or the legal remedies under, a legal dispensation can be exercised. And so we would go back to the drawing table, in an attempt to defend ourselves and then to affirm and then get a court to proclaim our innocence to the whole world. We would explore all the legal remedies, under, the law.
This are forced.
Absolutely. That's why I said, we think that it is not like, I read in a section of the media that says that we are afraid to open. No, nobody's afraid. From 6 years, 7 years, we have been here. All right, we have subjected ourselves as law-abiding citizens to, what the law says, all through from the circuit court now to the high court. So yes, but of course, the law permits us to exhaust, certain our right of redress, and it is for us to waive that right or, exercise it. So yeah, we'll go. I cannot, decisively stand here and then say that we are going to do that, but I have to speak to my lawyers, and then we can come to that conclusion or otherwise.
So I presume that the
charges that has been labeled, But as it stands right now, we are not guilty.
All right.
And I mean, that is instructive and very commanding.
Tell me-
And very painfully challenging. But of course, we leave that to what doesn't break you makes you stronger. And I'm a believer, whatever God doesn't permit doesn't happen. So it's fine. It's very fine. I'm not a person that complains. Anybody who knows me will tell you, I don't believe in complaints, right? I embrace whatever comes to me. I hold a challenge and I try to make the most out of it. So that's precisely what we're going to do.
Finally, before you go,
In terms of payment, we are very happy. We've been constrained. Every company has liabilities. I mean, companies lose money all the time, right? So it breaks our heart that people have had to suffer these unintended consequences. It breaks our heart, right? But we are before a criminal court. And if you know what the criminal court establishment is about, it is not a remedial court. It is a punitive court, a punitive and by extension a reformative court, right? So you come before a criminal court, you're not here to remedial, you're not here to remedy a situation by way of coming to pay debt. You are here, it is you against the state. So if they find you culpable, a punishment or a punitive sanction is imposed. So we are very happy. We want to exhaust this. Once we, by the grace of God and our firm belief in God Almighty, once we're able to exhaust this, then I believe we can the state may decide to go to the civil court, and at that point we'll be happy to make the necessary payment, discharge our payment obligations to our customers. I pretty much do. But I mean, one thing has to lead to the other. We need to take off this albatross of criminal liability off our back, and then we can look at it from a civil realm. Then when we go to the civil realm, it's between us and then those we transacted with that we can negotiate, all right, and find a middle ground and then do the necessary payment and we leave. Because before the criminal court, if you are making payment, as you guys all will recall, we started making some payment to the Ghana Police Service, right? We needed them. We didn't make the payment to them, but we needed them to aid us, give us security to be able to make the payment. But that effort has been thwarted by this criminal, proceeding or prosecutions. Because before the criminal, when you are before a criminal, proceeding, if you are making payment, what are you making the payment to? Is it to mitigate the punishment that will be meted against you if you are found culpable? Is it to stop the prosecution? What is it for? Yeah, so we cannot make payment before a criminal court, right?
A very confident Nana Mensah.
Absolutely, yesterday
saying he's not guilty.
He said he's not guilty.
Well,
that one,
of course,
he
he's
made that clear,
innocent until proven guilty.
proven
The
guilty,
fact that there's
so
a prima facie that has been established,
it doesn't mean he's guilty.
it doesn't mean he's guilty. So he will have to open his
Not at all.
defense.
So that is one education that we need to give to people. It doesn't mean that once the court has found that there's a case for him to answer, it means that he's guilty. No, I've seen a lot of cases in courts. The accused person will put up a defense, and at the end of the day, they are acquitted and discharged. So in this case, this is just half time. So now the court has all this while. All the court has been hearing is the testimony of the prosecution.
Yeah.
It is now time that the court is saying that it wants to hear from Namwan himself what he has to say in relation to the evidence being adduced by the prosecution. So one person who has also been speaking is the spokesperson for the Attorney General, Isaac Wilberforce-Mensah. Let's hear from him what he has to say about the decision of the court.
Establish a prima facie case, that means that you need to prove to a good extent, some of all the elements of the offense to which the accused person would be called to answer. So if prosecution had failed in this duty, then apparently, or as the law demands, the judge would have let the accused person or accused persons walk away. So it's very important. This stage of a trial, the submission of no case part of a trial, is extremely, extremely crucial. If you get this wrong at this stage, the accused persons would have walked. And the victims, the numerous victims you see behind us, it would have been a different story. So we are very glad the hard work and toil of the men and women of the prosecution's division of the Office of the Attorney General have indeed proved that what the French say, la loi n'aime pas le bruit, which means the law does not like noise. So it's been years, and we know when it comes to crime, there's no statute of limitation in respect of crime. This issue indeed has been in court. I've been reliably informed by one of you that since July 12th, so it was an exact date, July 12, 2019. This even predates when I joined the Office of the Attorney General. So it shows how long this matter has been in court. So we are glad that we have gotten to the stage of submission of no case, and the accused persons have been asked to open their defense. So this is victory for the prosecution. It's a step towards justice delivery in this particular matter. And I'm glad and I believe the gentlemen who are indeed at this stage can properly be called victims, I believe they're all satisfied and very elated and happy by the ruling given by the honorable judge today.
We know that you have 39 counts, but somehow along the line, you drop some of the counts. Why, and which are these counts?
Yes, so these counts relate to defrauding by false pretenses. And we did not drop these counts because we do not feel that, or we feel that the accused person is not liable to such offenses. We dropped the counts because the victims did not show up in court, or they indicated to prosecution at a very late stage that they will not come to testify. However, the prosecution was very resolute. The prosecution did not flinch and decided that we are going to go on. We believe we still have a strong case. Even if we have one witness, we are good to go. The documentary evidence to us was overwhelming, was very, very good and solid. And the witnesses were very eager to testify. In fact, as was stated in court, there were thousands of witnesses or thousands of victims in this particular regard. However, the court, even at the early stage, most of you were there, the court at the early stage admonished us that you can't possibly bring over 1,000 people to court. So we selected a few and we made a strong case in respect of the few that we had. And same has been confirmed by the court.
So that is Isaac Wilberforce-Mensah, the spokesperson or the Attorney General, also giving us his side of what happened yesterday in court. But of course, the victims themselves, led by Frederick Forson, the PRO of the aggrieved men's good customer yesterday, has been explaining how they received this very news and said that they will write to the Attorney General to ensure that whatever Namwan will say should be televised.
We want to know where our money is, and the court asking him to open a defense will give an opportunity to the prosecution team to interrogate where those funds that today we had some substantial amount of money were transferred even from remarketing accounts and men go to his personal accounts. We are also particularly happy about the issue of fraudulent breach of trust. As we kept on saying, those money that were transferred to xylophone accounts, which culminated in those celebrities enjoying from our sweat, we kept on asking them that they should do the needful by surrendering those property that they acquired. And so it's all well and good. We are very happy. We are very grateful. It shows the depth of work that has been done by the Office of the Attorney General, led by the Director of Public Prosecution. And so like we said initially, we are extremely behind them. We believe in their case, and we have cooperated right from day one till now. We shall continue to cooperate with them. And so come 23rd July, we'll come to the court and look at the other arrangements. We will wish that we shall officially write to the Attorney General that the cross-examination should be telecast. It should be made live for everybody to listen to it, because the justice that we are seeking. I have been defrauded. I have been scammed. I do not want somebody else to go through the same process. So we think that it's important the whole nation watch it live, so that the necessary lessons can be learned. If those of you who have been with us, and I'm sure all of you have been with us, ever since we fell into this trap, we have done everything possible to stop any other schemes that are presented as a scam to the general public when it comes to our attention. So we want to request that the cross-examination proceedings will be telecast live.
So that is Fred Forson, the PRO of aggrieved men's good customers, speaking to us after the court decision yesterday.
Interesting stuff. And they want it to be televised.
Yes, they
so
want
that
it to be
everybody will see
televised.
the answers
Yes, NAM1 will be given
that
to
are
them.
being given
Absolutely.
by NAM1.
Now, all cases that are deemed to be public interest, people want it televised so that everybody will say it.
People are interested in.
Absolutely.
They should go to court and go and sit in court and watch the proceedings.
the courtroom
but it's
is
good
not
for
too-
it's good for some of these cases to be televised.
Oh,
So that the
it
entire
is.
country gets to see what is happening. Like the Chief Justice has allowed the cases involving this
Anti-gay
anti-LGBTQ plus
Absolutely.
bill. And I think the last ambulance
one
case too,
yes.
it was allowed to be streamed.
Absolutely.
Right, because it's a
Yes.
matter of public interest. And
People
so
want to they don't want anybody to come and tell you what did not happen. So
Yes.
hear it for yourself.
Hear it
Make
for
your own
yourself.
judgments. Yes.
Exactly. Anyway, so let's talk about that particular case, the ambulance case,
Yes.
right? Where we understand that the court has been warning the parties over public commentary.
Absolutely. So Justice Ifiasewa Saribuchi yesterday indicated to the party that something has come to her attention, which is that the public commentaries on the matter is becoming too much many, and a lot of them have crossed the borderline for contempt, and so the court will not allow same to happen again, i.e. anybody, any party, any lawyer, any accused person who goes out there to make comments or commentary about the case is in trouble. So now it is clear. Justice Ifiasewa Saribuchi is saying that the law of contempt will bite hard at whoever flout this very directive, because the court said, look, for instance, you notice that I have indicated to you that cases that I have followed, that I have seen accused person engaging in media conversation immediately after court in relation to the ambulance case, and then that of the treason felony, Oliver Barker-Former, or these two persons have always been very vocal and all that. But particularly in relation to this very case, the court said what is happening out there, the public commentary by the parties themselves, is worrying, and the court will not allow that to happen. The media can report whatever they have to report as far as it is fair and it is not wrong or it is not lies. The court is allowed to that. But for the parties to come out there, Justice Ifiasewa Saribuchi is saying that no. And yesterday, Mr. Jakpa, the third accused person, was expected to call his first witness. In fact, Samed Sadash, who has been to be the representative of Big C, but that did not happen. Yesterday, his lawyers indicated that they filed a subpoena. A subpoena means you want to compel some people to come to court and help you make your case. And guess who the subpoena is directed at? One, Alban Babin, the current Speaker of Parliament.
The Speaker of Parliament
Yes.
is being subpoenaed
to come to court
to
and
come to
testify.
court.
Yes. He
Interesting.
said that what Alban Babin was the Minister for Health at the time that this whole ambulance thing started. So he has information that will assist the court. Then Alex Segbefia, he took over from
Alban Babin. Yes.
He's also expected. Initially he was one of the witnesses that Dr. Kasiela Tufose wants to testify for him. But along the line, he didn't come, or they closed their case without calling him. Mr. Jakpa says that he wants Mr. Alex Segbefia to come to court. Then El Commodore Edu Jemfi, Secretary of the Ghana Armed Forces, they want him to come and testify. You notice that during the concluding part of Jakpa's cross-examination, the Attorney General was confronting him with some documents suggesting that he was sacked from the military here and there and all that. He wants this very official to come and make things clearer to the court. Then one Professor Nuhu Zakaria, the Director of Ambulance Service, we are talking about ambulances and all that. Mr. Jakpa says that the court should compel this prof to come to court and testify. Then one Joycelyn La Kokoi Aziz, Director of Pharmacy at the Ministry of Health, Mr. Jakpa says that his subpoena is directed at this very person.
Why?
Then,
Why her?
Because-
What role does she have to play in that?
so that would have to be explained. In fact, yesterday when
I mean, for the others, we can understand why he
Absolutely.
would want them to be
So
subpoenaed,
you-
but this particular lady.
it was not clear why he wanted this very official, but once it has to do with ambulance and it has to do with health, and he's saying that he's a director of pharmacy, there are certain things that he said he is of the view that this particular person has to offer or assist him by way of getting explanation to the case before the court. Then one, Andrew Kufe, an officer of Controller and Accountant General's Department. You know, the issue of LC's letters going to the Controller General from the Ministry of Finance and all that. The Controller and Accountant General's Department played key roles, and he also considered view that Andrew Kufe has information that will assist his case. Then guess who? Dr. Sylvester Anemana. You know, Dr. Sylvester Anemana was the second accused person in the matter.
Yes.
And based on health grounds, he was discharged based on the Attorney General's violation of a nolle prosequa. Now, Mr. Jakpa says that he wants the court to compel Mr. Anemana to come to court and give him some explanation that will assist the case. Probably, if Mr. Anemana has testified, concluded his testimony, probably things would have been clearer to Mr. Jakpa, and he would not need him to come to court at this point. But he said that once he's no more in the case, the court needs to bring him back so that he will come and say what he knows about the case. Then one, Samuel Selas Mensah, a staff of the Public Procurement Authority. You know that when you are procuring certain things, the PPA is always involved and all that. He wants that person to also come. Then he also warned Juliana Asante, a staff at Stanbic Bank, one of the banks that some of these transactions went through and all that. He said that he has an information that will assist him to put out a defense. Then Lieutenant General Thomas Opon Pepra, and guess who the person is? Chief of Defense Staff.
Richard Jakpa is an interesting. Making this whole case very interesting.
And this witness, this particular, the Chief of Defense Staff, it also has to do with the allegations of that letter of him being sacked from the military and all that. He wants the Chief of Defense Staff to come to court to assist the court in order. So these are the people that Mr. Jakpa has a subpoena, and the court has granted his request. However, the court is saying that if you look at the list that you put before the court, you haven't mentioned that this very person will produce this document, that will produce that document. If you come to court, before you are telling the court that let Mr. Babin bring this document, so you should go home and come, the court said no, that won't happen. If they come to court with 10 fingers and they say these are the things that we have, whatever they have for the court will be it. No, nothing more, nothing less. So that is a clear warning to Mr. Jakpa. So before the case has been adjourned to the 18th of July for continuation. So that is what happened in relation to the ambulance case. So Mr. Jakpa is calling witnesses now. He's filed a subpoena which has been granted, but of course the court is saying that make sure that whatever they come to court, the court will not give them time to go and say they are coming back because of certain document. You didn't attach what specific document those people will come to court and refer to or assist the court with. So that is where we are in relation to the ambulance case.
Interesting stuff. So let's talk about today.
Yes.
What's happening today?
So the case with the highest number of witnesses, potentially 61. So far, the court has indicated that it has on record Psalm 29, the benchmark case. So if by today, so today is the deadline that Justice Efiasewa Saribotri has given for Mr. Nyineku and his lawyers to file the remaining witness statement of all the witnesses that they intend to call, those that have not been filed yet. I told you 29 have been filed. Mm-hmm. So 29, it means that close to about 30. More than 30.
Yeah.
Yes, about 32 more to go. So the court is saying that make sure you file everything by today. If today, by the close of today, you do not file, whatever is on record is what the court will work with. If you file after the close of tomorrow, today, you know, today is the last working day when you are talking about it. If you file today, 1 hour after, even 1 second after the close of day, it will be rejected. So that is the warning for Mr. Nyineku and his lawyer. So today we'll know more about whether they have filed more or it will end at the 29 that the court has, including those that they will also be coming by way of subpoena. So that is the case that we do expect today in court.
All right. Thank you, Murtala Inusa, as always, bringing us all of these updates. And we'll look forward to hearing from you again in the aftermath of this particular case.
Absolutely.
And we want to know what happened. But it's always great to hear what you've got to tell us from the courts with all of these very all of these very intriguing yes, cases.
So sometimes,
you know,
in relation to one case, you go to court, and the people will be asking you, so the crack saying court in this then.
What did the court say?
Absolutely. So sometimes you
Yeah.
hear, I remember so many times I would have to come out from the court and it was like, what has happened? The people who have their own kids did not even understand. Sometimes the court have made a certain directive. So the court has adjourned the case, or the court has ordered for certain things. They didn't even know what that's. So when you are telling us, is that what happened and all that? So it's not easy in court. You can be there, listening to all the things, but when it comes to understanding whatever processes have been taking place, it's a different act together. But of course, grace is taking us through.
And we pray that the grace continues to abound. Mutala Inusa, once again, thank you very much.
You have a great weekend.
Yes,
Today
you
is
too.
Friday.
Yes, thank God it's Friday. Thank God it's Friday. But I want to tell you, Mutala Inusa, that this weekend I'm unavailable.
Why? Why are you going? Why are you not available?
I'm unavailable.
Why are you not?
I'm unavailable.
This cannot be
They know they see me. I'm unavailable.
I know what.
They
If we
know
can't
they
see you this
see me.
weekend, no problem. We
I'm
know that Monday we will see
unavailable.
you.
They know they see me.